Mr. Pickford.
Thank you, Lord. So before the short adjournment, I was seeking to answer a question from my Lord Justice Arnold about why the ITC. We have essentially 3 points, 3 reasons as to why we like the ITC. The first, as we've heard, is that it's commercially meaningful. The second is that it appears to us to offer an opportunity for there to be a final resolution of the matter that has now been dragging on for 16 years, because if the ITC does find that our offer is within the FRAND range, we know what Lenovo's evidence is on its likely response to that. And in my submission, that's a good thing. That brings about finality. And then thirdly, we apprehend, in particular from the view that's been taken so far by the OUII, that we are doing well in the ITC, and we think we may very well prevail there. And that's another reason why we would like those proceedings to continue. None of those evince Ericsson seeking superfrand rates or acting in bad faith.
I mean, leaving aside superfrand and acting in bad faith, what it comes to is you think you can get high figures quickly from the ITC, through the ITC.
We think we think we may be able to get our offer quickly. We don't say it's high. We say our offer obviously is FRAND. But yes, we think we stand at least a reasonable chance of that, and we'd like to attempt that. And of course, if we succeed, then we say that's entirely legitimate. And if we fail, well, then there won't be any injunctive relief. And so in those circumstances, Lenovo hasn't got anything to worry about from the ITC anymore. So where that takes us is we say there isn't any hierarchy that requires that a FRAND decision in England should be promoted above decisions that could be legitimately taken elsewhere in the world, including before the United States EDC and IDC. And that is a fortiori when the English court is in fact the third seized forum behind both the EDNC and the ITC. So that's, in a nutshell, with some answers to questions before the short adjournment, my case on the comity point. Secondly, just in a nutshell on legitimate useful purpose, we say Mr. Justice Richards properly found that the relief wouldn't serve a useful purpose. Its core purpose, as I've said, is in fact to interfere with foreign proceedings, and in particular to scupper the ITC. Not only is that illegitimate, it's also unlikely to be effective, because I say rhetorically, why would Ericsson give up the opportunity that I've just outlined and the attractive qualities that accompany the ITC determination and exchange that for no longer being able to pursue those proceedings at all, but simply to have an interim license, which, as I shall come on to develop, it says it can't realise income under. I'd like to come back to that point, but that is going to be an important point to cover in due course. So that's, in a nutshell, legitimate purpose, useful purpose. Then, thirdly, Mr. Justice Richards rejected on the facts that it could be said with a high degree of assurance that Ericsson were acting in bad faith. There are 2 essential elements to that in my submission. One is that there is already an independent third-party view that Ericsson's rates are well within the FRAND range. That's the OUII. And Ericsson pursuing proceedings in order to obtain rates in those circumstances does not evince an intention to obtain suprafrand rates. It can't be inferred that that is in bad faith. Secondly, an essential ingredient which underpinned the finding of bad faith in Panasonic was, of course, as this court recognises, that Panasonic initiated the proceedings itself before the English court, and then it gave a mutually binding undertaking with Xiaomi that it was going to take the patent court determined license. It is hardly surprising, in my submission, that in those circumstances, the English court heavily condemned Panasonic's actions, because what they sought to do is render nugatory the very undertaking that they'd given to the court. And that was plainly not in good faith. But that is simply not the situation that we are in here. And then the fourth point is that Lenovo failed below to demonstrate that the terms of its proposed short-term offer, or short-term license, as it brands it, were FRAND. And that is not a decision which we say this court should seek to unpick on appeal for the reasons that I will come on to develop.
Why is that a relevant question?
I'm sorry, I've probably been unclear as to what issue I was covering.
So why is it relevant to work out whether what Lenovo has offered is FRAND?
I beg your pardon. It's a relevant question because it's not what it's offered. It's whether the short-term license is FRAND, and I think I misspoke and I probably confused my submission. The Lord Justice, I'm sorry, I promoted him. Mr. Justice Richards found that he did not have a high degree of assurance that what was being tabled as a short-term license was FRAND.
But if they say, well, we'll offer whatever the court says is necessary, that doesn't seem to matter very much. And really what you're saying is whatever you're offered, you don't want it. So the question is, in circumstances where Lenovo is willing to pay whatever the court thinks fit, is there reason to think that your refusal of that is in bad faith?
It matters, my lord, because of the issue about whether we actually get any real benefit. Even if a very high sum is nominally ordered, I will come on to explain by reference to the evidence that you've already seen this morning, that if there is no irreducible minimum, because Lenovo is saying, yeah, but actually you owe us.
That's one of the ways in which we stand in a different position to the judge. It's no fault of the judge, because matters have moved on. But there now is an irreducible minimum.
Well, I'm going to make some submissions on that, my lord, and in my submission there isn't. That you've heard from my learned friend who says there is.
Unequivocal commitment to pay an 8-figure sum, which is plus interest, which is an irreducible minimum.
Well, I'd like to come back to that if I may, but my submission on that will be
it's not what your clients have demanded, but as my lord has observed, they say they will pay whatever it takes.
Well, as I said, when I come to develop my submissions on that, but the point that I will be making is that actually the figure that you were shown is the short-term license offer. And then if one goes to both the statement of case on FRAND, the reply statement of case on FRAND of my learned friend, and his expert evidence served only weeks ago, those maintain that in the long term, it is Lenovo that is the net recipient. So all that my learned friend has actually shown you is a short-term position. In my submission, it is something of a conjuring trick to say, there you go, the issue has now disappeared, there's a irreducible minimum. There isn't, if one actually looks at the evidence. So that's the point that I'm going to come on to make on that. So, my lords, my lady, with those introductory comments, I'd like, if I may, to just pick up just a very few number of facts from below that we touched on, but could probably do with developing further. So the EDNC proceedings are covered by the judge at paragraphs 55 and following. That's in core bundle 1, it's core bundle tab 1, page 14. And there are just a couple of points to make in relation to these, because most of this has already been covered. The first one is it's been suggested that we that we outright refuse to make clear that what we'd like the EDNC to do is to determine whether Ericsson's offer is FRAND, to get rid of there being any risk that it won't. And what the judge records there is that we said that we were happy to do that, but as that hasn't yet translated through into the EDNC proceedings themselves, he wasn't going to change the position that he had previously arrived at in his previous judgment. But it's not right to say that we're refusing to do it. On the contrary, we in open court have said we're very happy to do that. So that's the first point to clarify. Secondly, just for your note, Lord Justice.
It's my fault. I'm not quite following. What are you saying is inaccurate about the judge's...
There's nothing inaccurate about what the judge says. Mr. Lykodopoulos this morning told you that we simply refused to allow the EDNC.
You haven't amended your claim.
We have not.
Are you saying that's incorrect as a statement of fact?
What I'm saying is that the position is slightly more nuanced than that. The position is as recorded by the judge in paragraph 55. So I accept paragraph 55. I'm not seeking to challenge it, but I say it's a nuance on the way that it was put by my learned friend. That's the only point I'm making. The second point in relation to the EDNC is my Lord Justice Arnold. Your Lordship asked some questions about parallel proceedings this morning to my learned friend, and for your note, it's worth noting that in the jurisdiction judgment, which is at the authorities tab 15, page 3, 9, and 8, at paragraph 80 and 81, there is I don't need to take you the court to it, it's just for your note. There is a discussion there of the fact that Ericsson was saying in that hearing, this is a really bad idea, there's going to be parallel proceedings, and the judge ultimately rejects Ericsson's position on that. So we didn't want these proceedings because we said they wouldn't be helpful and they'd lead to parallel proceedings and there would be problems. And ultimately, that position was rejected, so we're here. But it's not like we didn't try. And then the final point to make in relation to the EDNC, I think this may have come out clearly already, but the judge found that it could be the EDNC, or it could be the UK, or it could be both that makes a FRAND determination. Because of the timings, it's not clear which courts are going to speak first on FRAND, in particular because of the 2011 licence issue. So those are the only additional points I wanted to make on the EDNC. Then, when we come to England, there is an important point here, which is paragraph 64 of the judgment. There's a couple of pages on page 16. There is reference to Lenovo's position as it explained it to the court on the 2011 licence proceedings. And in particular, the penultimate sentence says that Lenovo also argues that the 2011 licence means that it is also entitled to pay a lower rate than it would otherwise have to pay for a licence of Ericsson's 5G SEPs. So there are two ways in which the 2011 licence is important. The first one is the one that was emphasised by my learned friend. It's a volumes issue. But the second one is it actually affects the 5G rate. And that remains the case. If I could show you, please, just very briefly, a letter from Kirkland and Ellis for Lenovo, which is to be found in the bundle. My reference here is core. Yes, it is core. Core bundle, tab 21, page 214. And you should see there a second letter of the 31st of January.
I don't have that.
Right, I do
Oh, I'm
apologise.
sorry, I do. No, it's the very last page. My thank you.
So we see there that letter. I only take the court to one paragraph, which is paragraph 3. So this is the way that Lenovo were putting their case and their offer as at the 31st of January. And it says for Motorola 5G smartphones, Motorola to pay Ericsson a rate that shall be determined by the English court when the MM license issues have been determined by the English court in action number HP, etc., or otherwise resolved between the parties. So the key point there is an answer to a question from my lord this morning. It isn't the Franz trial that they say will be determinative of the 5G rate. They're saying we have to wait until the 2011 issues have all been determined, and they're not yet listed for full trial. So if I made the next point I wanted to turn to on background is the ITC. And you will have heard this morning that the ITC is a non-partisan entity within the executive branch of the US government. We could probably go back to the core bundle tab 1 and pick up the judgment here at paragraph 66. Just pick that myself. And an important point to make here, which I made before, but just to show the court that it's a finding of the judge below, the ITC is going to consider whether Ericsson's offer is within the Franz range. That's what the judge finds is going to happen before the ITC. Now, in that connection, before this court, Lenovo has raised a point that it never raised below about exclusive jurisdiction and the 2011 license and the impact of the 2011 license in relation to Franz issues. If I could please just address that by going to the OUII brief, which the court will find in the supplementary bundle at tab 20, and we begin on page 240. So at the top of 240, one sees the finding in the staff's view, these licenses, so they've been looking at comparables, show that Ericsson's offer is within the Franz range. As discussed below, there are disagreements as to the unpacking methodology. The comparable licenses show that the $1.52 per unit royalty is well within the Franz range based on the unpacking from both experts. So that was where it started in relation to comparables. We then continue to page 244, it's down on page 244. And one sees after the big black box, about halfway down the page, that Lenovo didn't provide expert testimony regarding Ericsson's 5G component. Lenovo's primary argument is that the offer does not account for the 2011 MMI license. As discussed below, the offer explicitly states that Ericsson would not collect for licensed 4G smartphones. And then over the page, page 245.
Just before you go there,
yes.
In terms of what's then said under the heading, the staff is of the view that Ericsson's understanding of the 2011 license is not so unreasonable as to show that the offer was in bad faith. That's not purporting to rule on the 2011 license.
No, No, not that sentence, but if I could show the court what the OUII does go on to do, over the page at 245, there's then a whole subsection of its analysis which deals with the 2011 license. So it's titled 2011 license at the top of page 245, and then there are a number of pages of analysis of the parties' competing positions under it. We'll see on page 246, for example, that Lenovo, one sees under the large box there, it was stated the 2011 MMO license is governed by the laws of the United Kingdom, and which refers to the laws of England and Wales. That was Sir Christopher Floyd, who gave expert evidence on behalf of Lenovo in relation to that. What one won't see is the jurisdiction argument being raised here. You won't see Lenovo saying, we've got this 2011 agreement, but I'm afraid it just means that you're going to have to stop analysing these issues because there's an exclusive jurisdiction clause and you can't do it. On the contrary, it put the 2011 licence in front of the ITC and asked the administrative law judge hearing these proceedings to consider the issues. And one sees that there are pages and pages in the OUII's brief devoted to an analysis of that very issue. And one gets to page 250, one sees the statement in the staff's view, even if first it rejects Lenovo's construction arguments on the 2011 license.
Does it?
Yes. If you it's the bottom of page 246.
Well, it says that the understanding is reasonable and does not indicate bad faith. Where does it purport to construe the license?
So it then goes on to say, under the 2011 MMO license, Lenovo's 5G smartphones are not commercially reasonable updates or extensions, CRU, of the Motorola smartphones from 2011. And my understanding, although I have to confess I'm not particularly close to this part of the case, is that the commercially reasonable update or extensions argument is at the heart of the 2011 license arguments. So the question is, are Lenovo's 5G smartphones CRUs or not? Because if they are CRU, then they're licensed, and if they're not CRU, then they're not. So they do then go on to make findings of at least at the level at which the OUII considers these matters in the following pages of its brief.
Yes, I mean, there's a further reference to Ericsson acting in good faith.
Yes.
At the bottom of 247.
Exactly.
And saying effectively at the end of 249, but I haven't yet seen a clear answer to my question.
So if I may, before just before we go on from oh sorry, that is 249, I beg your pardon. So obviously the context in which all of this is arising is a question about, somewhat similar obviously to the things that Mr. Justice Richards was considering below. Is there evidence that Ericsson is acting in bad faith? And so that is ultimately those are the guiding lights for the analysis of the ITC as well, because it's being asked to consider whether it should refuse an injunction because Ericsson is acting in bad faith because it hasn't made a FRAND offer. And so that's the context in which all these issues arise.
No, I see that, but that sort of shows that it's a different issue from what the actual FRAND terms would be.
Well,
because come the point at which you determine FRAND terms, you have to determine them. You can't just talk about whether a construction of a license is a reasonable one.
Well, in my submission, it goes between the two. Sometimes it talks about what is reasonable. Sometimes it actually makes fine. Obviously, this is the OUII, of course, as well.
Yes.
I mean, I don't want to overinflate it. This is not the determination of the administrative law judge or of the commissioners. This is just the brief that was submitted to the court, effectively a type of amicus style brief. So
indeed, and I think it's apparent, isn't it, that the focus of the process, the actual decision that will be taken, is, as you say, effectively centred on the good faith.
yes, but quite, but encompassing whether the Ericsson offer is within the FRAND range. That's the important point. Now, I totally accept it's not going to then determine FRAND. So it isn't going. So what it has to do is it has to make arguments of exactly the style which I'm going to show you that it does make on page 250, which is to say, okay, I've heard these various arguments. Do they make a difference to whether I think that the offer is within the FRAND range? And that's exactly how it approaches the 2011 license issue. So one sees at the top of page 250, it says, in the staff's view, even if Lenovo's interpretation that it was already licensed to about 1/3 of Ericsson's declared central patents is correct, Mr. Mills testified that Ericsson's offer is still well within the FRAND range. And then ultimately, it comes on to conclude that that's what it, for what it's worth, agrees with. So I'm not showing you, my lords and my lady, this to show you, look, these matters have been determined. I'm not remotely suggesting that there's some that this is either a judgment or that there is a FRAND determination. What I'm taking the court to it to show is that this idea that it has been accepted by the ITC that they can't touch the 2011 license arguments and therefore they can't possibly even adjudicate on FRAND is simply not correct. They were raised by Lenovo itself in front of the ITC, and it is grappling with them insofar as it needs to on the substance. That's the essential point that I'm drawing from this.
I mean, presumably they didn't have any choice but to point out the point about the 2011 license.
I can't answer that, my lord. Well, I mean, in my submission, it would not necessarily have been impossible for it to say there is this issue, but unfortunately, you have a big problem here, and you can't cover it, and therefore stay these proceedings, please, until the English court has spoken on the matter. If they thought that there was a jurisdictional problem, for the avoidance of doubt, Ericsson does not accept that there is an exclusive jurisdiction clause. Certainly one that operates to prevent the other courts or the ITC from considering these issues. Those are my instructions. I don't actually have the agreement.
So in these proceedings being disputed, because we had this in the previous appeal, it wasn't disputed on that occasion. There was an exclusive jurisdiction clause, nor is it disputed anywhere in the papers that I've seen.
Well, can I just clarify that I got those? That's what I thought my instructions were. Obviously, I wasn't in those hearings. I just want to double check that I'm not misstating what I was told. Our pleaded position is that we don't accept that there is a formal exclusive jurisdiction clause. That's. I'm afraid I can't show you it, and I'm not really capable of arguing it, to be totally frank. That is on instruction, but just in case it was said, oh well, you heard that in court and you didn't bother to say what Ericsson's position was.
All one has to do is look at the document. I mean, you may be right, I don't know. For all I know, looking at the document would show there is no exclusive jurisdiction clause, but it must be possible very easily to confirm that one way or t'other by showing us the document.
I hear what my lord is saying. I can't really say more than I've said. But what your lordship says is well noted, both by me and obviously by those behind me. If I could then please turn to Panasonic, which we'll find in the Joint Authorities bundle, tab 21 and 610. And I'm going to pick it up, if I may, on page 620. So there's a statement at paragraph 25 by your lordship referring back to Optus and Apple. Your lordship's comments in that. And the essential point being there that the court can only enforce the court's Fran determination against the SEP holder by withholding an injunction. That's only in the ordinary case, but then, as 26 makes clear, this case is different because of the undertakings which both parties have given. And then at paragraph 36, those undertakings are set out, and it's noted that those undertakings are central to the present appeal. And then we go on at paragraphs 79 to 80, which are paragraphs on which considerable weight is placed by my learned friend, to the court's comments on the role for injunctions in relation to SEPs. Now, what we say about these paragraphs is as follows. We, of course, accept that the rights inherent in a SEP are different from ordinary patent rights because they're subject to Fran commitment. And certainly the consequence of that in England is that an injunction granted pursuant to the Fran regime is indeed to enforce the SEP holder's right to a financial remedy. But what we do say, additionally, is that the position on injunctions, and in particular interim injunctions, which is what Ericsson sought in Brazil and Colombia, is not the universally adopted approach across the world. There are some jurisdictions where the courts consider that it's legitimate, at least to grant an interim injunction without there having been a full court determination of Fran's terms. And one sees that, obviously, in injunctions that were granted in Brazil and Colombia. To that extent, the point being made here, we say, reflects an English law view, but it's not a world view.
It's French law.
Well, it's how the English courts have approached the question of whether they should grant injunctions under their discretion to grant injunctions in the light of French law, in my submission. So I would respectfully submit it embraces a question of French law, but seen through the lens of the English court's own discretion as to whether to grant an injunction or not.
But the injunction isn't withheld as a matter of discretion. It's withheld because there's a contractual defence under French law.
Well, in my submission, that there are courts, particularly in relation to interim injunctions, applying the test for interim relief in those jurisdictions, which take the view that it is permissible, taking the test that they apply.
I'm not disputing that is factually accurate. The evidence is plain to see. What I was questioning was the proposition which I understood you to be advancing, that the English approach was based upon an English law exercise of discretion. And at the moment, I'm completely unpersuaded of that, because at the moment, it seems to me that what we do in this jurisdiction is not to exercise any discretion with regard to injunctions. If the implementer is indeed the beneficiary of an ETSI undertaking, then the consequence is that there's a contractual defence to infringement, and therefore there is no question of any injunction because there's no infringement.
Well,
And that's applying French law.
well,
Now, you may be factually accurate when you say other jurisdictions don't share that analysis. But that's a different question.
well, in my the particular point of one particular point of difference is, of course, the injunctions that are relevant in Brazil and Colombia are interim injunctions, and the English court does have a discretion as to whether to grant an interim injunction. In obviously in this jurisdiction, considering American cyanamide principles or whatever other principles might be appropriate in the case, and it doesn't grant interim injunctions in these types of cases. But that,
applied for. I mean, how do we know? Because it's not been tried.
well, in which case my point is I would say is a fortiori.
Actually, I speak wrongly because, of course, it was tried in this very case.
Yes.
And the answer was an injunction wasn't granted, but the reasoning was that damages would be an adequate remedy.
Yes, and obviously the only point that I'm making, and obviously I haven't made it very clearly so far, but the only point I'm making is in relation to the interim, the only injunctive relief that has been sought and granted, which is interim relief. That is all that the Colombian court and the Brazilian court is doing, and so far. And in my submission, that is not inconsistent with the any analysis of the French law implications of clause 6.1 of the ETSI IPR policy. Perhaps I can, if I can put it that way, that's perhaps all I need to say.
Well, I've no idea, because I've no idea to what extent the Brazilian and Colombian courts have been taken to clause 6.1, to what extent they've been shown evidences to French law. I mean, for all I know at the moment, the point was never argued.
Well, I'm not going to try to go further than I have done in relation to that submission. So that's my position on it.
Yeah.
Where I go with this is that we say, whilst a willing licensee is entitled to take an actual FRAND license from the moment it implements a SEP, it's not entitled to hold up the mere entitlement to a license as a bar to injunctive relief anywhere in the world, irrespective of whether it's committed to accept what the court in the country that's considering injunctive relief has said about FRAND. So, for example, if you're sued in country A and you say, oh, but I've undertaken to take country B's determination of a FRAND license, that doesn't act as an automatic bar to an injunction. The court below made that clear at paragraphs 45 to 50 of its judgment by reference to the judgment of Mr. Justice Mead in Nokia and Oppo. And I don't understand that that principle is challenged by my learned friends. None of those paragraphs of the judgment below are appealed. So then if I could go on a very brief canter through the rest of the core bits of reasoning that we say the court should pay attention to. At paragraph 81, your lordship begins that the key factor in the present case is that, as explained above, it's certain that the parties will enter into a global license of Panasonic set portfolio on the terms determined to be FRAND by the Patents Court in the relatively near future. And you'll have obviously heard my submissions on why we say that doesn't apply to us. We then have the point which I think my learned friend did take you to in paragraph 83, about halfway down, being critical that Panasonic has itself invoked the jurisdiction of the English courts to determine what FRAND is on a global basis and undertake to accept the determination of the patent courts on that question. Again, that being absolutely core to why it was found to have been acting in bad faith. Then at 84, there's the point made that any rational SEP holder in the position of Panasonic would positively want the implementer to enter into an interim license. And as I say, our facts are different for two reasons. The first one is that if we did enter into an interim license, that would scupper our ability to seek injunctive relief in our chosen forums. And those proceedings are legitimately brought, and therefore we are entitled to have regard to that. That is not, it's very unlike the situation where you've gone to one court and said, I'll take the court's determination of Franz, please, and then you go elsewhere, in Panasonic's case to Germany, to then actually try and scupper the first proceedings. We brought our proceedings first, and we're entitled to pursue those proceedings. So that's the first and most important reason. And the second one, which I'm going to come on to, is that because Lenovo says that it's the true recipient under a cross license, we can't book any of the revenue.
The second time you've said that, so let me direct you to what Lenovo say in their supplementary skeleton argument of paragraph 13. This is Core Bundle tab 6, page 117.
Thank you.
And what they say is that the latest offers both propose the lump sum value of attributable Lenovo's portfolio will exert on the evidence is now developed lower than that of Ericsson's portfolio. As such, it is no longer a position that Ericsson will be found to be a net payer to Lenovo pursuant to the foreign cross license. This means that the accounting point relied upon falls away. Although Ericsson may ultimately be found to be entitled to a lower sum than any short-term license royalty point, it will not be in the position it will have to repay it in full. So I read that as an unequivocal acceptance by Lenovo that it was going to be a net payer. I put that to Mr. Lukadopoulos and he confirmed that. So they're stuck with that. Whether they like it or not in the future, they're now stuck with that.
Well, there is some difficulty, if I may say, in relation to that, because
It may be contrary to your previous understanding, but it's there in black and white.
Well, for my part, I don't know what the irreducible sum is, because when one goes to the evidence of Ms. Dagg, her evidence is premised on a short-term license. It's not premised on explaining what the irreducible sum would be under a long-term license. If we could please go to her evidence, which is at tab 21 of the core bundle.
Sorry, just maybe I'm being slow, but surely the license we're talking about is a short-term license because it's only pending the determination.
Well, my lady, as my lady said, I think this morning, what we need to compare is the position under the short-term license with the position under the Lenovo is advancing in the proceedings in relation to the final license. Because if it says, I'll pay you X under the short-term license, but then its position in the proceedings at large in relation to a final.
The point, you're dealing with the fact that Ms. Dagg's evidence is premised on the basis of a short-term license, and I'm simply making the point that that's what we're talking about.
Yes, exactly, my lady. So I'm saying that the fact that so her evidence is premised on a short-term license point, and therefore one cannot infer from it, as Lenovo seek to do, that means that their position about the full FRAND license is now that they accept that there is an irreducible minimum under it, because all they're actually talking about, and all Ms. Dagg's evidence goes to, as my lady rightly says, is the short-term position.
Yes, but I thought the point you were making is about the short-term license. The accounting point is about not being able to book income in the short term.
Yes.
Nothing about the long term.
No, it does depend on the long term. If I may, it wasn't really explained by Mr. Lukatopoulos in
The
these
evidence
terms.
that explains, the judge didn't have the evidence that explains that.
So the evidence in particular was the evidence that Mr. Lukatopoulos took the court to this morning. And if I could just explain the point first, the point is this, that Lenovo say, look here, have X under a short-term license. You should love X. Look, it's lots of lovely money. Why are you turning down X? And my point is, if it were the case that what was being offered, if X was an irreducible minimum, so that we were always going to get at least X, then we might be able to book X, because we would know that whatever happened in the proceedings that followed, there'd always be that amount. So, for example, in a normal one-way license dispute, if the party, the implementer, comes and says, "Well, I think that your portfolio is only worth 200 million," and the patent owner is saying, "No, my portfolio is worth $500 million," and the implementer says, "Well, there you go. I'm not waiting around. I'm putting 200 million on the table as an interim license. So at least you got that. Then you could book the 200 million. But the difference here is that their case, as to Frand, is that they are going to be the net recipients. So it doesn't matter whatever they put on the table now. They say we're going to whip it away ultimately, and we will pay you more."
That's completely disregarding the January offer. You're absolutely right. That was their position in the past, but the January offer is a movement on that in your direction.
Well, if I may, then, if I could go back to Ms. Dagg's evidence. So
You're absolutely right. The calculations she does are down to the end of 2025, because, of course, what she's directing the court's attention to is what the financial impact would be if the court is in favour of Lenovo on the principle of an interim licence. But the offers that the calculations are based on are explicitly for a cross licence ending 31st December 2028. That's her paragraph 15. So the offers are for the full licence. So the January 2025 offer is for a full licence, and then, consistently with the methodology in Panasonic, she does a calculation as to what that yields in the period to the end of 2025.
Well, if I could point, that's very helpful, my lord. But if I could point the court to paragraph 16 of her statement, and the first sentence says, "Solely for the purposes of this appeal, on the short-term licence declaration, and without prejudice to Lenovo's position in respect of the upcoming English Frand trial and the 2011 licence proceedings."
Sure, that's the calculation. Absolutely right. Yes.
But, well, we read that, we say, to get together with, if I could please go to their reply statement to case.
It comes back to the offer itself, and you took us to the 31st January letter earlier in your submissions. And it says very clearly, unless otherwise stated otherwise, the rate stated applies to all sales made up to 31st December 2028. So this is a 2028 offer.
My lord, I do come back to the point that firstly, one cannot see what the irreducible minimum that we would never have to repay is in a final licence. And secondly, if I could please take the court to the reply statement of case of Lenovo, which is in the supplementary bundle, at tab 27, page 320.
this is back in October.
This is back in October, but I'm also going to take the court to something from January this year. But they haven't sought to amend this. And at paragraph 4 of that reply centre case, it says the parties are agreed that a FRAN licence between them it's about 2/3 of the way down, would be a worldwide cross licence, although the parties disagree as to which party will be the net licensor.
They did at that stage.
And then, well, and again, that is littered throughout that. Then, if you go to their expert evidence, which is at tab 28, so the next tab in the bundle, and you go to page 326. In particular, paragraph 76. I've been told by Kirkland and Ellis that it's not necessary for me to comment in detail in relation to these payment provisions at this stage, as the parties disagree as to which party will be the net payer under the settled cross licence. This is a statement from only the 22nd of January 2025.
Yeah,
Now,
but still 7 days before the latest offer.
well, my lord, what we haven't had from Ms. Dagg in her evidence is our position was X, and of course it was our position was that we were going to be the net payer, the net payee, as late as last week. But now I will make very clear that our position has changed, and so we no longer accord to the position set out in our reply statement of the case, and we no longer accord to what our instructions were to our expert. She doesn't say that. She's very careful to say it's without prejudice to their ultimate position, and so for those reasons, I say that there isn't sufficient evidence before this court to conclude that this problem has gone away, even if there is some irreducible minimum somewhere that could be calculated, and I don't know what it is. We haven't been told by my learned friend what it is. It still seems to be likely to be a very small number in comparison to the kinds of numbers that Ericsson legitimately believes that it is entitled to and may well get as a result of the ITC proceedings. And so what it is being asked to trade is a chance of commercially final determination of this dispute that's been dragging on for 16 years, and under which it will get a certain amount of money, potentially a very large amount of money, and to replace that with, in our submission, an interim licence under which they can record nothing. But even if there is some irreducible minimum, a very small sum. And in my submission, it can't be inferred from the reluctance to take that trade that Ericsson is acting in bad faith. It's in my submission pretty obvious why it wouldn't want to take that trade, for perfectly good faith, commercially sensible reasons. So,
I mean, that obviously is an absolutely core issue. Can it be inferred that you're acting in bad faith? And plainly, by taking the stance you are taking, you have hopes of achieving figures of your choosing and getting money now. I mean, in another sense, the flip side of that is you are asking for figures that you may or may not get on a FRAN determination, and seeking to do that by putting Lenovo in an impossible commercial position now, even though eventually it would be entitled to a license that would cover this period.
in my submission, it's not, if one scrutinises the evidence of what is actually the position it's being put in, it's not in a commercially impossible situation, unless
it chooses not to take what you're unilaterally offering.
No, not at all. And unless the ITC agrees that our offer is within the FRAND range. If the ITC agrees that our offer is within the FRAND range, then we accept on the evidence that Lenovo has adduced, it has a problem. Obviously, there's a slight difficulty for me in making submissions on this because some of this is in.
Well, it's an obvious problem. I mean, they're at risk of being excluded from the US market.
Yes.
And you know, the commercial ramifications of that are entirely obvious.
Yes. And I say there is nothing improper about that.
Yeah, you're just exercising your rights. It's very straightforward. You
Yes.
say this is how the patent system works. Patents are territorial. We have national rights. We enforce them nationally, and you are just using a procedure that is available to you under US national law.
Yes.
It's entirely legitimate.
Quite. And we're not doing it in an abusive way. In contradistinction to Panasonic, what we're not doing is seeking to scupper the very proceedings that we initiated.
It's my understanding, and correct me if I'm wrong, that one thing that is common ground in these proceedings, and always has been, is that any FRAND cross-license will be global. Correct?
I certainly believe so. Yes, no one is taking it ahead of me.
The party is arguing for country-specific FRAND license.
Yes.
And in your submission, is that relevant or irrelevant? And let me just try and explain the question, because I appreciate when I, having just said that, it makes out a bit vague. And the question is this. One perspective on this whole problem is that actually the original sin was committed by the Supreme Court in Unwired Planet, in saying that the courts of one jurisdiction should set FRAND terms on a global basis. So one argument is that actually the right answer to all of these problems is to go back to where we started in this world, which is national enforcement leading to national licenses. That's the old way of doing patent licensing. But as I understand it, you're not arguing for that.
No.
You do not say that country by country enforcement leading to country by country licensing is the right way forward.
Correct.
So you are positively arguing for a global solution.
Yes.
And how is it consistent with that to have national injunctions?
Because those are the only injunctions that are available to us.
But in circumstances where you have got the possibility of FRAND determination on your first choice by the ED&C, failing that by the English court.
Well, the only thing, I mean, if one was to say there's an inconsistency between national injunctions and global FRAND, the inconsistency would be that you should be able to get worldwide injunctions to go with worldwide FRAND. And
no court has jurisdiction to do that.
exactly, no court has jurisdiction to do that. And so all we're seeking is something less than that, which is a national injunction in the United States. And the fact that we're seeking what the United States courts and or ITC can offer us does not render our approach abusive. In anything, the inconsistency works in our favour because we're seeking something less than we're only seeking to impose the lever of a national remedy in order to determine the global dispute.
But it's not to determine it, is it? It's to force the other side to accept your terms.
Well, they're only going to have to accept them if they're adjudged to be within the FRAND range. If they're not, then we're not going to get we're going to have egg on our faces, and we're not going to get the relief that we want.
Does one know that they're within the FRAND range without determining what is FRAND? That's the mystery to me at the moment.
Well, there is evidence. I can't take you to it directly, but the evidence in the proceedings, and I think it's actually recorded by the judge, is that there was a 6-day evidentiary hearing before the administrative law judge of the ITC in relation to these very issues. There were experts who gave evidence. There were fact witnesses who gave evidence. There was cross-examination before the administrative law judge. Now, in those circumstances, the fact that the adjudicating body is going to confine itself to the question, is this within the FRAND range, in my submission, is not an unreasonable approach. Yes, they're not saying this is the number, but they are saying we believe that what has been, or not. I mean, they need to decide one way or the other. But if they side with my clients, they'll be saying we believe the offer is within the FRAND range because look, we've got these comparables here, we've got these calculations that we did here, we unpacked these things, we're looking at this, we're looking at that, and we're saying, yeah, within the FRAND range. Or they're going to say, no, we don't. We think you're asking for too much. You're outside the FRAND range. Don't go home. You don't get your relief.
I mean, supposing that's right, then what would be being said would not be, obviously, that is the correct FRAND figure. They would be saying, well, it might turn out to be the correct FRAND figure. Is that fair?
No, I think they'd be saying something slightly more than that. They'd be saying whatever the outer, because it's. So first point is the English court, this was Unwired Planet in the Court of Appeal, takes the view, just as the US regime does, that FRAND is a range. So that's point one. And so what the US court would be doing if it decided that our offer was in the FRAND range, which was the first question that was asked, and what the ITC will be doing, likewise, is saying that this offer is FRAND because it's within the FRAND range. So that is different from saying, as an English court might potentially do, well, we're actually going to decide a particular figure, and then we go, which we say is like our central estimate of FRAND, and then potentially put a bound on it, you know, a plus or minus. They're not approaching it in that way. They're approaching it in a different way. But in my submission, it's not that the conclusion will be this might be FRAND. The conclusion would be it is FRAND because it's within the FRAND range.
Potentially, then you're greatly underselling yourselves, I suppose, because I think OUII at least says, well, it's within the FRAND range, even if Lenovo is right about the 2011 license.
Yes.
So theoretically, supposing that Lenovo is right about the 2011 license, presumably you could have asked for a lot more.
Yes, that is the implication of the OUII's statement. And of course, there was evidence below on this, but Ericsson runs a successful licensing program. It has many people who have signed up to take its patents. It's having particular difficulty with a company called Lenovo. So it's perhaps unsurprising that its offer was, in the view of the OUII, well within the FRAND range, and it could have asked for more.
Are you leaving the question of the accounting principles? I'm
just trying to think what I have and haven't said on the accounting principles.
Well, just briefly, it's asserted that because there would be the potential to give money back, that would be treated in a particular way in the accounts.
Yes.
Then the question is, well, does that matter? And I think the most you get on that is Mr. Foster saying in brackets, meaning Ericsson could not use that money until a final license is signed.
Yes.
Now, he obviously is not an accountant, is not an expert, not speaking as an expert. But, I mean, just as a matter of common sense, that cannot literally be true. you get all the money in, you put it in the bank. I mean, as a minimum, you put it in the bank and earn interest on it, presumably. You are using it.
Yes, albeit, of course, if you have to pay, if it's all at risk, then any interest you earn on it is only going to be potentially short-lived because you're going to have to pay it all back.
Could be, but he says, Ericsson could not use that money. Well, that can't be true. So what evidence is there as to what could not be done with this money that otherwise might be done?
I think the evidence is probably the most important paragraph is 88 of his fifth statement. And someone helpful on my side is going to give me a reference to that. I think it's supplementary. Actually, I think I provide my own reference. It's supplementary bundle, tab 19, page 215.
That's the one with the brackets, meaning Ericsson could not use that money until a license is signed. But that can't be true, or can't be right.
Well, I think, sorry, if you bear with me, you're ahead of me, my lord, because I haven't actually managed to get to the right paragraph yet, but okay, I've got to it now. Okay, so what we have at the beginning of 88 is the statement, Ericsson does not consider that Lenovo's interim structure would leave the parties on an equal footing. And so just to put this in context, paragraph 3 of this witness statement explains that when Mr. Foster is talking about what Ericsson thinks, that's on the basis of instruction from its Vice President for Patent Assertion and Enforcement. So what this paragraph, in my submission, is doing, it is basically explaining how Ericsson sees the world. It's not trying to be a definitive expert view on accounting practices. It's saying, here's Ericsson's perspective on this. And the reason, of course, Ericsson's perspective is relevant here is because all of this ultimately is under the umbrella, is what Ericsson's doing. Can we infer from what Ericsson's doing that it's acting in bad faith?
Yes.
So that's the first point to make. And then what Mr. Foster, I beg your pardon, just momentary brain block, then says is the problem in these circumstances is that Ericsson is not going to be able to recognise it as revenue under generally accounted principles. So if it can't recognise it as revenue, it's not, even if it can put it in a bank account and earn interest on it, it does not have the same advantages as winning in the ITC it's going to have for it, because then it gets real money, no question about it, and it can book it and say, look.
I mean, obviously, if there's no possibility of having to repay it, that's an advantage. But it isn't immediately obvious to me why the accounting treatment has real-world consequences that matter. And it just cannot be the case that they could not use the money. They must be able to do some things with the money.
Yes. So
and it may be they could do anything at all with the money that they otherwise would have done.
Well, I'm willing to accept that the statement it can't use the money in parentheses is not one I'm seeking to urge on this court.
Yep.
I am sticking to the statement that it can't recognise it as revenue under generally accepted accounting principles. And I say that is a serious disadvantage for it, because ultimately what it would like to be able to do is have income that it can show its shareholders, say, look, we're making a big profit. And if it can't do that, that's obviously
transparency is what it's all about. Why does a court judgment not provide transparency? And put the existence of the judgment to the accounts as well.
Well, the only evidence that we had on this, which was, so there was an opportunity for reply evidence below. No point was taken on this below. It was never said, well, you've adduced Foster, but here's the true position as a matter of general accounting
Yes,
principles.
I put it to Mr. Nicotopoulos, he hadn't put forward any evidence and answer, and he had no answer to that. However, I repeat my question. If the problem is one of transparency to shareholders, why does a court judgment, which is public, and if need be, you can reference the public judgment in the accounts, why does that not provide full transparency to shareholders?
Well, in my submission, it would not be the same being able to not record revenue, so your profits look, to anyone who isn't doing a forensic and legal analysis of your accounts, your profits look X £100 million worse than if you can book the revenue, and your accounts recognise that you've managed to secure a really important revenue.
Submission that nobody reads the notes to accounts. Yes.
No. That's not my submission. Not that no one does. I mean, I
understand accounts unless you read the notes, because you have to understand the basis upon how they're prepared and what they mean.
Well, it's not my. I maintain the point that I've made before, and that's not equivalent to saying no one reads the notes to accounts, but also there's massive uncertainty, as anyone reading the accounts would see, because what we seek in the ITC is the certainty of commercial resolution of this 16-year running dispute. And if Lenovo enter into a license because the ITC say it's a FRAN license, it's within the FRAN range, and if you don't enter into it, then I'm afraid we are going to impose exclusion orders on you. In my submission, there is a palpable and obvious benefit to that to Ericsson, and you do not achieve the same benefit by having entered into an interim license for whatever sum, and we don't currently know what that sum would be, but even if it were a sum that is the same amount, where it said, of course, all of this might have to be repaid, because we haven't got to the end of this dispute yet, and the person who's paid its position is that actually they're going to be the net payee. And I can't put it higher than that. In my submission, that those are clearly and very different, and one is commercially far superior to the other.
So I mean, and I understand your position. I think you say it's not just transparency. We actually want to say we've got the money.
Yes.
So we have the accounts look better.
Yes.
And I don't mean as a matter of transparency. I mean because you really got the money on an out-and-out basis.
Yes.
Yep.
So I'm going to have to just check where we are. So what I was in was Panasonic, but obviously we've been on a very helpful, but nonetheless quite a detour in relation to explaining why we weren't on all fours with what was said by Lord Justice Arnold. I think it was at paragraph 84.
Well, I mean, two key points you've hammered home already, which is you didn't start the proceedings in this jurisdiction, you haven't invoked the jurisdiction, and you haven't given any undertaking.
Yes.
To accept this jurisdiction's determination. Those are the two key differences. Is there any more to it than that?
Those are the key ones. Just very briefly, your Lordship observed at paragraph 85 that in reality Panasonic was only disputing the terms of the interim licence anyway. That really it was just a debate about what the terms were going to be. For the reasons that I've already explained, that is not us. There's then the analysis of useful purpose, and if I can just summarise very briefly what I take from Panasonic in relation to that, it's at page 636 and following. It seemed to be, in my submission, it was implicit that if the declaration did not have a useful purpose, then it wasn't going to be granted. But your Lordship considered that it did. It was all about changing Panasonic's mind, and your Lordship referred back to the previous analysis, and obviously it's with some trepidation and hesitation that I suggest what was in your Lordship's mind, been referring back, but I'm going to give it a go at least for a few seconds. In my submission, there were three important points there. Firstly, the one that Panasonic had invoked the jurisdiction of the English court, so there was little reason, if it was willing to take the final licence, why it wouldn't take the interim licence. Second, Panasonic had in reality only really disputed the terms of the interim license rather than the principle. And thirdly, that Panasonic had shown a history of changing its position. Most egregiously, it did that before Mr. Justice Mead, when it backed out of an undertaking not to enforce foreign injunctions. And then they changed their frowned offer, as your lordship had highlighted in the judgment. So in my submission, those were the core points as to why there would be a useful purpose in Panasonic, and none of them apply here. And then finally, the position on comity is at paragraph 94 and following. And obviously the key point there, we've already got it, it was about protecting the integrity of the English proceedings. And I've made the point that we're not doing anything wrong here in England that undermines the integrity of the English proceedings. So, and then, of course, there's finally then the dissenting judgment of Lord Justice Phillips. The most important point there, of course, is that all the court were agreed that Panasonic were acting unconscionably. The only question was, well, how do we bring Panasonic to heel and make it see the error of its ways? The only point just to touch on there, very briefly, is what Lord Justice Phillips says at paragraph 104.1 in relation to his approach to the ETSI obligation. He said, whilst Panasonic's ETSI undertaking no doubt gives rise to obligations to act in good faith in relation to the negotiation and or determination of the terms of a FRAN licence, I do not see how that translates to an obligation to enter into an interim licence during that process. And that was essentially the position that we adopted on the ETSI IPR policy and French law below, and that's the subject of the respondent's notice. So that's just so you know where we're coming from.
That is inconsistent with the majority, isn't it?
That is inconsistent with the majority. But my submission on that is that these were questions of French law as applied to facts, namely the ETSI IPR policy. So we were permitted, it was permissible for us to make those submissions to the court below, notwithstanding
Yes.
what the majority has said. So that's the only point there.
Yeah.
So I think I've obviously, hopefully, covered quite a lot of what I was going to be saying in my principal submissions in relation to the court's questions. What I'm going to do is therefore try to race through the 4 grounds. So starting then with comity, we say that there are 2 additional authorities that we cite in our skeleton argument that are relevant beyond Panasonic. The first is cited at paragraph 27, and so you'll find that in core bundle, tab 5, page 96. Sorry. And we cite the general principle on comity as described by the US Supreme Court in the seminal case of Hilton and Goyer. The only real reason for taking the court to this is that not only is it a foundational case, it explains that comity extends not just to respect for another jurisdiction's judicial acts, but to respect for another jurisdiction's executive acts. Now so that will be obvious to the court why I'm making that point. It extends to respect to the acts of the ITC. For the reasons that I've also explained, we say the difference here is actually pretty theoretical, because it's a quasi-judicial procedure in front of an administrative law judge. There was, in this case, a 6-day evidential hearing. And there is a right of appeal to the US Court of Appeals for the Federal Circuit. We'll see that. I'm not going to take you there, but for your reference, it's at first Pinkett, paragraph 26. That's supplementary bundle, tab 5, page 65. And we don't understand that Lenovo, in fact, say that you should not afford the same respect to the ITC as you would afford to
No, I don't
a court.
understand that to be an issue.
Thank you. So the next point we just to draw attention to from the skeleton is the statement in paragraph 30 in Tiva UK Novartis. It's my Lord Justice Arnold's statement. The basic point being you don't give a declaration solely for the purpose of influencing the decision of a foreign court. And to do so is jurisdictional imperialism. My lords, my lady, I think on this ground, I'm at risk of repeating myself now because of the answers that I've given to the questions that very helpfully came from the court. The basic point is, it's said that the primary purpose of this declaration is to make us reconsider our unlawful conduct in the UK. We're not doing anything unlawful here.
Do you need the word? I remember perhaps you do. I mean,
Is
the word unlawful needed? Well, I say it's unlawful in the sense that it would be a breach of the French obligation of good faith, ex hypothesi.
Well, I mean, obviously, I've used the word unlawful because that's Lenovo's case. But
I've seen the unlawful. Maybe I'm missing the point. Is not the unlawfulness the alleged breach of French law?
Well, there is nothing. There is nothing that we are doing here, in contradistinction to Panasonic, about which we say Lenovo can complain. It's very simple. We haven't given any undertakings that we're seeking by the backhand to.
We're now straying into different points of whether there's a breach of good faith and whether there's a useful purpose. But the moment you're arguing comity, and your key point there is very straightforward, which is you say, in reality, on your case, this is all about influencing foreign courts and tribunals, and that's illegitimate.
Yes. Yes. Unlike it.
Yeah. It's as short and simple as that.
It is, basically.
Yeah.
Because all the ways in which it's put, whenever my learned friend tries to put it in a way, it says, it's about protecting the integrity of the English proceedings. When you analyse them, they always come back to what's going on elsewhere. They always come back to stopping what's happening in the ITC in order to protect the integrity of the English proceedings. And to which my answer is, there's no hierarchy. If we get an injunction in the ITC, we're entitled to it. End of story. There is a further point here on the 2011 license issue. We've dealt with that. I showed you the parts where that's currently in issue in the ITC. There's a point which was not pressed by my learned friend in his oral submissions, but it is in his skeleton, where he says the US ITC is cognizant of the fact that issues pertaining to the 2011 license can only be determined in this jurisdiction. That is simply wrong. And I'm not. I don't think I probably need to hammer that home much more. But what is relied upon by my learned friend to make that point is the Commission determination in a parallel set of proceedings before the ITC. So they refer to Ms. Dagg's evidence, and Ms. Dagg in turn refers to Commission determination, which is at core 21, page 202. You can see everyone picking up, so we'll go there briefly. So this is the determination which is said to make good the submission that the US ITC is cognizant that, of the fact that the 2011 license can only be determined in England. You will not find that anywhere in this determination. On the contrary, what you will find, which is on page 204, is that when the Commission reviewed the FID, which I think is defined above, it's the final initial determination of the administrative law judge. What they decided to do was only take a position on one of the issues, namely about validity, I think. And it says about halfway through that final page, 204, that the Commission takes no position on a number of issues, and then finally on the FID's findings regarding the respondent's licensing defence. So it simply didn't take a position, and the case referred to there simply says you don't have to take a position on things that aren't dispositive. You're perfectly entitled just to ignore them, and if you don't take a position, then there is no finding by you, obviously, on those issues. So in my submission, that's just simply a bad point in the skeleton taken against me. So my very final comment then on comity before turning to the other grounds is what the implications would be if this court were to accept Lenovo's approach to the development of the law in this area. In my submission, it would have bad, potentially pretty disastrous consequences for the Frand legal order, because what would happen is this. Any defendant in set proceedings who is scared that it may be subject to an injunction in a key market, thinks the case isn't going too well, could go off and approach the courts of a second jurisdiction, initiate proceedings there, and undertake to take the second court's Frand determination. And then on the back of that, they'd then turn around and say, well, they don't need the first proceedings because we've undertaken to take your Frand determination and you're a very good court. By the fact, and also we'll enter into an interim license. So by the very fact that we're willing to enter into a license, you should give us this declaration which scuppers their first proceedings. And one can see very easily that that would be a charter for forum shopping, for general confusion, and for a lot of satellite litigation. Added to which, if one now supposes that the second jurisdiction that's been approached isn't England, it's a notoriously slow jurisdiction.
Sorry, can you explain to me why is forum shopping by implementers bad and forum shopping by SEP owners good?
Well, we are entitled to bring proceedings in any court that we wish to.
So the submission is the SEP owner is always entitled to shop for whichever forum it wants, and that's good, and forum shopping by implementers is bad. Why?
Well, I suppose because, in particular, of my second reason is that it's liable to lead to confusion, because because
surely a dispassionate view would be that forum shopping by both sides should be deprecated. No?
In my submission, there is nothing objectionable at all about choosing the forum if you are a patent holder, in which you think you are likely to.
If you're a patent holder, but why is it the patent holder's choice? Why is the implementer not got a choice?
Well, of course, these proceedings are continuing in England, and no one is stopping them necessarily from reaching a determination. Whether they reach
you're running a floodgates argument and saying this is going to cause chaos. And the reason why you say it's going to cause chaos is because of forum shopping by implementers. But that rests upon the premise that forum shopping by implementers is illegitimate, whereas forum shopping by SEP owners is legitimate. And what I'm asking you is to justify that premise.
Well, my position is the reason why it's particularly problematic is because of the confusion that is liable to follow if whenever a patent holder goes to country A and seeks to enforce its patents in country A, the automatic response to that, to try to scupper those proceedings, is to go to country B and begin litigation there with a view to preventing any relief being obtainable in country A. In my submission, that is liable to lead to satellite litigation and to cause confusion, irrespective of the view that one takes about the relative acceptability of forum shopping on either side. I'm happy to make my submission without it resting on the proposition that forum shopping is desirable by patent holders and undesirable by implementers. That's not my submission, and I don't need to make it to make good the other points that I make. Because what that does do in terms of undermining the ordinary legal order is it immediately takes the attention away from the first seized jurisdiction. It means we're suddenly having satellite litigation in a second seized jurisdiction. And that is, in my submission, not conducive to an orderly FRAND regime. The other point that I was going to make is that, of course, if the second country that the implementer goes to is in a notoriously slow jurisdiction, and it were to grant this so-called interim relief, the effect of that could be to stymie proceeding basically indefinitely, and certainly for as long as a license might last. Because even in England, we know this isn't a short-term license. This is a license that will in fact last way beyond 2025 because of Lenovo's position that we need determination of the 2011 license issues before we even know what FRAND is. So even here, we're looking at many years, and in another jurisdiction, the whole thing begins to potentially just break down. So, my lords, those are my submissions on comity. In relation to utility, the judge's key factual conclusions are paragraphs 127 to 129. But given the time, I'm not proposing to take the court to them. I'd just like to make submissions on them unless it would be helpful, unless the court will find it helpful for me to go to them, basically. There are 4 arguments that are advanced by Lenovo on utility, certainly in its skeleton argument, and I think they're maintained in the submissions I heard this morning. In essence, the first and the third are about forcing Ericsson to reconsider its position. And this follows very swiftly from the points that I've already made on comity and in response to questions from the court. The rhetorical question, why on earth would we want the trade that's being offered? It doesn't make any commercial sense. We're being asked to trade in the possibility of a final commercial determination of our dispute for something which, although one might argue about the finer edges of how useful it is something that's obviously much less helpful to us than final commercial determination of our dispute, namely the interim license. And that is the essence, really, of the point on it being required to get us to reconsider. We're not going to take this license is the bottom line, because obviously it would be silly for us to do so. Next point is the one that we were dealing with on the value of the short-term license, and I don't think I've got anything more to say on that. I think I've made my points about that issue. Really, the only thing that I think remains to say is that in the light of the way that the evidence was advanced by Mr. Foster, it was permissible for the judge below to rely on that evidence. It's not expert accounting evidence, we accept that, but he didn't ignore any competing evidence because there wasn't any. And it wasn't irrational for him to form the views that he did about how, from Ericsson's perspective, it didn't seem to be offering us very much for the reasons we've explained. Then I've already addressed, it comes back under utility, but I've already addressed the court on the question of protecting the integrity of the English proceedings. I don't think I need to say anything more than that, than I have done. And then the final point that was made in the skeleton, but I don't think it was advanced, I'm not sure it was advanced by my learned friend, was it was said that the judge erred because he failed to find that the declaration would have additional utility in the foreign proceedings, because the judge said that he rejected that utility would be significant. And we say that's simply a hopeless complaint about the weight that the judge gave to evidence, and the fact that he didn't side with Lenovo. There's no error here for the Court of Appeal. So that is utility. Good faith. A number of points are made on good faith. I'm going to see which of those I think I need to continue to make in the light of the debate that we've been having. First point, at least, that's made by Lenovo in its skeleton is that it says the judge never asked and still less answered the central question posed by Panasonic: what's the point of Ericsson pursuing its global campaign of litigation with all the attendant effort and expense of in these circumstances? It's wrong that he didn't ask and answer that point. He addresses it at paragraph 97 of his judgment. And the simple point is one I think the court will already well have. It's obvious what the point is. The point is that we think legitimately we may well get a good result, and there's nothing wrong with pursuing proceedings in front of the ITC in particular to do that. Second complaint about the judge's approach to good faith is it said he gave decisive weight to the fact that Ericsson had declined to commit to offering a license. We say that mischaracterizes what the judge did. It was a factor he took into account when weighing the significance of Lenovo's undertaking. One sees that at paragraph 116 of the judgment. But he also took into account that Lenovo had given no unconditional undertaking to the EDNC. One sees that at paragraph 118 of his judgment. And he also took into account that he couldn't conclude to a high degree of assurance that Ericsson was failing to act in good faith generally, including in the light of the evidence on Frand. So it's wrong to say that it was determinative, but nonetheless, it plainly is a highly relevant factor, because for all the reasons I've given, it was at, in my respectful submission, the core of the court's reasoning in Panasonic, and it is entirely absent in our case. And then what's said about that is that, well, if you accept that submission, that positively rewards Ericsson for conduct, i.e. not giving an undertaking, which further reflects Ericsson's lack of good faith. But in my submission, that is a bootstrapped point. It's not incumbent on us to promise to take the Frand determination of whichever court Lenovo wants to come to, and that's the end of the matter. Third point they make is they say the judge's conclusions on good faith were vitiated by his attempting to analyse to a high degree of assurance whether Ericsson's October 2023 offer was or was not Frand. But we say they're implicit in their case is the contention that the only explanation for our conduct is to secure supra-Frand rates. So it wasn't irrational for the judge to at least seek to investigate that issue in a way that was proportionate and sensible, given the interim nature of the application before him. And what he considers was most helpful to him in that regard was the OUII brief. And in my submission, there is no reason to attack the judge on that front. That was a perfectly sensible and reasonable thing to do, and within the ambit of his discretion. What Lenovo say about that is, well, you shouldn't have. He shouldn't have done so. In particular, they say, well, he shouldn't have done so because he didn't also consider their evidence advanced through Ms. Dagg on Frand. And there are two difficulties with that submission. The first is, as the judge himself recorded, I think it's paragraph 123 of his judgment, but I'm going to ask someone to check. Lenovo's case was that the court didn't need to actually determine Frand. It didn't need to consider the expert evidence on that issue. So it's hardly surprising that the court then didn't seek to do so on an interim application. And also, it's all the more unsurprising that it didn't, given that it is, in essence, expert evidence, and it was advanced by someone as learned as she is, who is a solicitor of the court, but not an expert in the technical sense in Frand. Final point on this ground is it suggested that the judge erred because that what he should have found, I think what it said is he should have found that where the parties disagree, an offer can't be Frand unless it provides for the terms to be determined in court. And so that was another way of trying to say that the only Frand solution here is Lenovo's interim or short-term license. And we say that is an anathema to the very idea of Frand being a process and the outcome of a bargain between willing parties. Because that would be to suggest that all bargained for, or virtually all bargained for licenses were non-Frand unless they had a clause with a reckoning up in them. So those are my submissions in response on the issue of good faith. And then the final point here is on the short-term license and whether the judge was entitled to find that it wasn't Frand. It might be helpful here actually to go to the judgment, please, at paragraph 103. So that's core 1, page 23. And this contains a very important point in my submission, because it goes to the way in which Lenovo were putting their case below. As Lenovo argues, there is nothing special about the short-term license, and that it is wrong to describe it as an interim license. While the license is potentially short-term, Lenovo argues that it is still a Frand license, with the result that the basic obligation in clause 6.1 obliges Lenovo to offer it. I do not have a high degree of assurance in that analysis for the following reasons. So that was the way in which it was being put below. I'm not quite sure, in response to the answer from my learned friend to a question from my Lord Justice Arnold, whether it's still being put that way now. I think they're seeking to shift to some degree from that, but the difficulty is they made their case in the way that they made it below, and they were very clear when they said this is a Frand license. It's just it's just like any other Frand license. The obligation to grant it arises under clause 6.1, and so please grant it. It's Frand. That was their case, and unsurprisingly, in response to that case, the judge was not convinced that he was able, on an interim application, to determine a Frand license. So the complaint that we have from Lenovo in paragraph 56 of their skeleton argument, when they say that the judge was wrong to analyse the proposed license not as an interim license, but as a species of normal Frand license, is puzzling.
I understand the point you make about where Lenovo are. in terms of the judge's analysis, he refers twice to this court's decision in Panasonic, and in particular, he refers to what was done in terms of terms for the interim license at paragraph 109.
Yes.
So that seems to be a recognition it is different to a final Frank license.
Well, I accept, my lord, that he obviously does. I can't dispute that he refers to Panasonic, but nonetheless, he was ultimately dealing with the submission that was made to him, and the submission that was made to him is the one that he records at paragraph 103. Now,
well, okay, let's start with precedent. Do you accept that Panasonic was binding on the judge?
I accept it was binding on all issues of English law.
Yes, right. So was he not bound to apply it, regardless of the way the case was argued?
No, in my submission, he wasn't, because of course there might be multiple routes to relief that is sought, and there might be reasons why a party chooses not to particularly pursue the analysis in down one route, and they go another route. And Lenovo expressly and deliberately went the route of saying this is a FRAND license under clause 6.1 of the IPR policy. Now maybe that was a bad idea, but that was their case.
But it depends what you mean, because all of the analysis that the judge goes through in the succeeding paragraphs are pointless if the debate is all about the terms of a final Frank license. Now, it may be that there has been some confusion caused by differences in terminology. But is it your submission that the judge was what A, did consider, and B, was right to consider matters on the basis that what he was under consideration was no different to a final FRAND license?
No, I'm not saying he was approaching on the basis it was no different, and I think the passages that then follow after 103 make it clear that he had some that obviously it was different in the sense, in particular, there was going to be a reckoning up clause for one, but nonetheless, it was appropriate and correct, in my view, for the judge to approach it on the basis on which he was being asked to determine it in law by Lenovo. He can't be criticised as having made an error for approaching on the basis.
You've accepted that he didn't treat it as being a final licence, and therefore, what's the difference? I'm struggling to understand the difference as a matter of terminology, other than the difference in terminology.
Well, I think the important point is he understood that he was being required to find something that he could at least have confidence in his view was FRAND under clause 6.1 of the IPR policy. And he did not have the confidence on the facts before him that he could. Those facts include, of course, differently from Panasonic, the issue about the ability to recognise the income given, or recognise the monies paid rather, as income, given the position adopted by Lenovo, certainly before him, which was that it should be the net recipient. And his position was that he didn't think, taking all the matters that he considered in the round, that was FRAND. In particular, I'm being referred to paragraph 105 of the judgment, where he says, if the short-term licence were an interim licence designed to hold the ring until a final FRAND determination, I'm prepared to assume, without deciding, that willing licensors and willing licensees might be prepared to adopt a more rough and ready approach to setting the rate, recognising its interim nature. However, if the short-term licence is to be analysed as a species of a normal FRAND licence, its terms would need to be FRAND. In order to be non-discriminatory, it would need not to be unduly generous to either Lenovo or to Ericsson. So he was simply seeking to analyse the very question that he had been asked to analyse, which is whether what was being offered was FRAND, because that's what the submission to him was. That was the basis on which he was being told he should order it, or rather make the declaration, which might have the effect of us entering into it. So Lenovo say. And in my submission, he can't be criticised, given the way that the case was put, for approaching it on that basis. And having decided and having approached it on that basis, it was reasonable for him to come to the conclusions that he did, in particular, as I said, because of the non-recognisability point, which I've already addressed. I'm conscious of the time. I'm also conscious of the conclusions that the court and my lord took or came to in Panasonic. The issues in our respondent's notice concern essentially French law points, and they only arise, of course, if I failed on any one of on all of the first 4 points, because they need to win on comity, they need to win on useful purpose, they need to win on FRAND, and they need to win on good faith. As the points are set out in our skeleton, and somewhat in the court's hands as to how much time you'd like me to devote to this. I mean, I don't abandon the point.
No,
I continue to make it.
I think you'd better develop it briefly, orally at least.
I'm grateful. So the key point here then on respondent's notice is that there is an additional reason, we say, why the judge's finding below should be upheld. Because if he was wrong to decide the principle of good faith under French, the principle of good faith under French law could lead to the creation or modification of a party's rights, such as to lead to the obligation on a SEP owner to offer an interim licence, then that would be an additional reason why he shouldn't have granted the relief that he did. You can see the way he approached this matter if we go to his judgment starting at paragraph 24, which is core page 8. So he records the judgment of my Lord Justice Arnold at paragraph 49 of Panasonic. If I could just ask the court to read that. And then he records at paragraph 25 what we said about it.
Let me just get over the date point first of all, because what he says in paragraph 26 is that both sides were agreed that Lenovo served the notice together with its evidence and reply on 11th of October. Now, in your grounds of appeal and skeleton argument, you seem to be attempting to resile from that agreement because you argue that it was in fact served on the 14th.
We make that point. I don't press it hard. We didn't make it below. I'm simply setting out for completeness what the true facts are, but I'm not seeking to press that point hard before.
Thank you.
So you can see the way, yes, that he reached, that he began his analysis there, as I've just shown you, and then the position was obviously there was a notice that was served under section 4.2 of the Civil Evidence Act 1972, which had that very proposition that we've just seen in it.
And so the next point is whether that was in time, and the judge says it was in time because what CPR 33.7 says is you've got to serve by the latest date for witness statements, and he says, well, it was served by the latest date for witness statements because there was provision for witness statements and reply by the 11th of October.
Yes. And
you read in, that's got to be witness statements in chief.
Yes.
What's the justification for that?
The justification for that is because if it didn't work that way, then the provision would be capable of acting very unfairly. Because if you can save up your notice, which is, as we saw in this case, something that the judge thought was something of a trump card, and you deploy it in reply, then you deprive your opponents potentially of the opportunity properly to respond to that notice. You'd have to make then very late applications to reduce evidence to respond to whatever issue was set out in the notice.
I mean, I see the sense of that, but the rule says he must give the notice if there are to be witness statements not later than the latest date for serving them.
Yes.
Well, if you've got a regime under which witness statements are potentially to be served on the 11th of October, and you serve the notice on the 11th of October, how is it earlier than the latest date for serving witness statements?
Well, I accept that one has to read in to that rule that it's talking about primary evidence. I also accept that those words are not there, and that this is the third. to be totally candid with the court, this is the third of my 3 points on the respondent's notice, and I'm under I'm under the clock. Yes. So I'm not going to take up more of the court's time seeking to persuade the court otherwise. You have our position on it. I'd like to devote what short time I've got left to the other points, if I may. So
his point is he was wrong on the burden of proof, but I don't understand that, because the statute says unless proved to the contrary.
Yes, well, in which case, if I could take the court, please, to a key case that we rely on in relation to that question. So that's the case of Phoenix Marine, which is at tab 4 of the authorities bundle, page 28. And could I ask, please, the court to go to what is, yes, but sorry, I'm starting at page 28 of the report, which is the internal page numbering 143. Could I ask, please, the court just to remind itself of the sidelined section there?
It seems to me to be a discussion about the standard of proof, not the burden of proof.
Well, I'd like to make, if I may, the point where I say the judge went wrong is what he did was basically approach the matter as follows. He said, I've got 3 things here. I've got the notice, I've got a witness statement from Lenovo, and I've got a witness statement from Ericsson. And so what I'm going to do is I'm going to say, well, naturally, it's an interim application, Lenovo and Ericsson's witness statements cancel each other out, and therefore I'm left with the statement under Section 4.2 of the Civil Evidence Act. That's the way he basically approached it. And so he then...
Your grounds of appeal that I'm discussing here is that the judge was wrong on the burden of proof. And you have just referred to an authority which is speaking between B and C about the standard of proof. How does that detract from what the statute says about the burden of proof?
I need to track back to see exactly how he put it. If I can explain what our point is, and then I'll come back to what the respondent's notice says. The point is this: what the judge did is exactly as I described. He said there were 2 conflicting statements from experts. Therefore, I'm going to decide this on the basis of the notice. But in fact, the way in which Section 4.2 operates in relation to burden is more nuanced than it might seem. So the way that it in fact operates, as he then was, Mr. Justice Moore-Bick explained, is that if you have both a notice and evidence served, you don't just automatically transfer the burden back onto the person who is responding to the notice, as if to say, well, those two things cancel out and therefore we just leave the notice. What you have to do is look at all of the evidence in the round substantively. So it's basically, there's a threshold that you get over the section for, if there were no evidence at all on the other side, then obviously the way that section 4.2 operates is the burden is on the party that's facing the notice, and inevitably it will lose because it has no evidence. As soon as there is other evidence there, what the court needs to do is substantively engage in all of the evidence. You need to substantively engage in both the admissible evidence that's made admissible in terms of the prior judgment, and also the statements of, the statements of the experts in that case. And the judge didn't do that. He took it in a very with respect, in a formalistic way, where he just says these two things knock each other out, therefore it's the notice, and that's the point. And so it is a point on burden in this sense, is that he overinterpreted the effect of section 4.2, and he gave it more force than it in fact has. It doesn't automatically lead to the approach that he thought it did, because if it works like that, basically it always ends up being a knockout blow, because you just net off the two experts against one another, and then you're just left back with the notice, and that's not how it's supposed to work. That's the point. And then the final point is this. That dealt with the prior French law issue about whether you could effectively read rights into an obligation so as to modify the obligation under 6.1. What we said he needed to do, on the basis of the way that Lenovo put its case below, which was saying this all arises under 6.1 of the ETSI IPR policy, this is a species of license that you are required to grant under 6.1 of the IPR policies. We said, well, you've got to apply that French law principle to the ETSI IPR policy. And we argued below that even if it is correct principle in law, that you can, in some circumstances in French law, imply in new obligations. That doesn't mean that you always do it. You obviously have to look at the ETSI policy, its words, its purpose, and we argued all of that before him, and he didn't decide any of that. And on the basis of the way in which the case was put, he needed to decide those issues. But he thought that because there was a section 4.2 notice, that the whole thing was basically done and dusted. That's our other point. So he failed to address one of the issues that he needed to consider, given the way in which the case was being put, as you saw in paragraph 103 of his judgment.
Yep.
My lords, my lady, unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Pickford. Mr. Nikodopoulos.
My lords, my lady, it seems from what my own friends has submitted that a lot of this case comes down to the fact that Ericsson thinks it has an ability, the right to seek injunctive relief from the exclusionary order from the ITC, and has every right to exercise that right. And the reason, he said, very candidly, openly, was they thought they'd get a good result. And what he means by that is a better result than they think they might get if a court reviews the position. He gave three reasons why the ITC, and most of his submissions were focused on the ITC. He said commercially meaningful, opportunity for a final resolution, and they're doing well there, they think. And one can actually put all those to one reason, which is exclusion order. That's why it's commercially meaningful. That's why they feel it has opportunities for final resolution. The beauty of an exclusion order is that it means they get their way without courts reviewing the position. And his only fig leaf on that, and we say it is a fig leaf, is to say, well, it will be reviewed at the ITC. Which means we do need to be very careful about what is to be reviewed at the ITC. And what my learned friend kept saying was they will review whether our offer is in the FRAND range. And one has to be careful with a phrase like that because it means different things depending on context. There is no dispute, and the judge found it, that the ITC is not a rate-setting body. Moreover, at times my learned friend referred to it being where in the United States FRAND rates are determined. That is not right. That would be the district courts. The ITC is not a court and is not a FRAND rate-setting institution. And at one stage he referred to a license resulting from the ITC. That again would not be right. There would be no license from the ITC. The ITC's statutory founding and what it's there to do is to consider, in the event of an infringement of a US patent, whether an exclusion order should be made, and it for that looks at the public interest that I have submitted about. As regards FRAND range, well, one has to be very careful what that means. It is the range of offers consistent with good faith, and I showed you that, but in light of how my learned friend has put his case, I need to, if I may, just show it briefly again, which is in supplemental bundle, tab 20. Page 225. And what you see there at page 225 is the Newey, which my learned friend accepts as he must. This is not a judgment we're looking at, or even a preliminary opinion. It is a brief. But they cite the law. And you see they cite Microsoft and Motorola and the fact that initial offers do not have to be on FRAND terms so long as a RAND license eventually issues. And all the way through, and I won't go through it again now, but I took my lords and my lady to it, we see reference to whether it's in bad faith or a reasonable position for negotiation. And indeed that hangs together in my submission with what the judge found at the jurisdiction hearing with the evidence from the US judge there about the EDNC, because what was being put there, which the judge accepted, was where the request is, has Ericsson met its FRAND obligations? What the judge there, the US judge explained, was that that can be, following Microsoft and Motorola, an assessment of good faith, and an offer actually can be supra-FRAND as an initial offer, but within what is then the FRAND range. And so it does fit together because both the district court, in the formulation that my learned friends have requested in their claim, and the ITC are being asked a similar question. The actual question that this court is here to determine is an actual what is the FRAND license, cross-license in this case, and as we've seen, the ITC is not being asked that question, and the EDNC is only being asked that conditionally. And we say this is akin to the German approach when they, again, are looking at whether to grant an injunction following a finding of infringement, and as has been canvassed in many cases, the German courts approach the matter more under Article 102 competition law issues. And I won't go to them now, but for my lord's note and lady's note, they are set out and the various judgments that refer to that are set out in our supplemental skeleton argument at paragraph 9, and cases such as Nokia Oppo, and in fact recently Lord Justice Arnold in the Amazon and Alcatel case. And if one wants, just stepping back, a real feel for what the difference might be, it's how actually, my learned friend says, the UI here in their submissions deal with the 2011 license issue. We do not accept it was raised there for determination. In a proceeding such as at the ITC, Lenovo had no choice but to raise the fact that there's this issue and to explain the issue as a reason to say there should not be an exclusion order. Not you can determine the construction. And nowhere in this brief does the UI attempt to construe the 2011 license. What it does is it makes submissions as to whether or not it feels that Ericsson's position is reasonable or not in bad faith. A very different position, determination. And one can see that it's very different when one thinks about the result. If the ITC was to follow what is said in this brief and decide that Ericsson's offer meets its FRAND obligations because its position on the, as part of that, its position on the 2011 license and its position on the cross license is not unreasonable or in bad faith, my clients might end up paying hundreds of millions of pounds too much. I showed you the evidence that has not been said to be wrong from Ms. Dagg, but that is what's at stake on that issue. And it is shows in my submission why, of course, they're very keen on an ITC type approach. It also shows where they're not very keen on a court determination of the FRAND rate, taking all the issues into account. And one has to ask again, having heard my learned friend, well, what is it that is wrong with the interim license? Even if this court was to say we pay them effectively what they're asking for in the period up to in the short-term license, based on their evidence. And really in my submission, it always comes back to one thing, the adjustment clause. What they don't like is the fact that the amount is open to review by the court. Now on this side of the court, we do not mind if that review is done by the United Kingdom court, English court, or by the Carolina court, and I'll come on to the Carolina court, but we are not forum shopping. We are saying we want this determined. And my learned friend's position in the end is they do want it determined, but they want it determined by injunction in our main market. And that will directly affect these proceedings in my submission. You've seen the evidence. If we are, if they proceed on that course, then they, and my learned friend was open about it, feel that they may get what they want. And we say that is directly contrary to an undertaking they signed for their benefit to have their technology put into the standard. They were more than happy to sign an undertaking under French law to create a French law contract with good faith obligations to grant licenses on SEP terms. They did it for a good reason, because their technology then is entered into the standard. But what comes with that is they must do and follow through and grant licenses on FRAND terms to implementers who are prepared to do so and have undertaken to do so. Now, my Lord and Lady, briefly on the EDNC, a point was made that actually they put to the judge that they would amend the
The question was raised about the 2011 licence, and apparently it's disputed, it has an exclusive jurisdiction clause. So what's the answer on that?
Well, that surprised us. We understood it was not an issue that it has an exclusive jurisdiction clause. It's not in the bundles because of that. What I do find in the bundles, however, is in JA2, tab 2. Sorry, I say JA2, that's my bundles. JA tab 20.
Well, you're referring to what I said last time. That's what I mentioned to Mr. Pickford. And I wasn't correct it when the judgment went out in draft, but that could have been an oversight on their part. And I was, of course, relying upon the information that had been provided in the hearing. Maybe I was misinformed.
Well, my lord, I was going to take you, and my lord is right, at paragraph paragraph 21, where it says that the exclusive jurisdiction is in favour of Wales, and nothing turned on it there. Nobody corrected that, and my understanding is it does. At the moment, I can't give you a copy, and I know that, but we could give one to the court afterwards.
Well, can you send us a copy of the relevant page?
Yes, of course. Then I was going to turn to the, and may I, sorry, my lord, I'm trespassing on the court's time briefly, but I won't be, I'll keep it short.
Good.
EDNC, it was said that they would be prepared to amend the claim, and the reference went to the judgment at paragraph 55. Just looking at that briefly, they haven't done it, but it still isn't amending it in the way that the judge at the jurisdiction hearing said would solve the problem, which is to seek a FRAN determination. Again, what they say they would change it to is to address the issue of whether Ericsson's offer and its terms is FRAN. So again, they haven't done it, but again, what they seem incapable of doing is saying from the outset, we will simply ask the court to determine a cross-license that's FRAN. We've now seen that the court, the EDNC, is effectively dormant for the last year. That was the evidence. But we have remained, and we've always said that if Ericsson really wants to have things determined in the EDNC and wants a rate setting there, we're not forum shopping. We've always said we will do that. Our caveat, and it is a caveat we stand by, is you can't go to a court that is moving extremely slowly on any view, ask us to commit, and then exclude us from the United States in the interim, or exclude us somewhere else. So we stand by that. But our position in the UK, and why we're asking for this relief, is not about that, it's about the actions here. And as I've said, my learned friend has been extremely clear that because he says they can get an exclusion order in the United States, they will try to do so. And my submission that entirely ignores the obligations and the good faith obligations that his clients have accepted. There was a discussion about the net payer point. I'll simply restate what I said.
If it's restating, then that's definitely not
I
needed in reply.
restate that what I said before is correct, that we are standing by what we said in our skeleton argument, and that we stand by the point that at the FRAN trial, we will be the net payer for all the reasons that were canvassed between my learned friend and my Lord Justice Arnold beforehand. And so, the earlier reply statement of the case, I understand, is being in the process of being amended, but has not been yet. Then, just on the short-term licence, my lords and ladies, and then a lady, and I think then I've trespassed enough on the court's time. There was a debate just at the end with my learned friend about the judge's approach to assessing the short-term licence as whether or not he had a high degree of assurance that it was, or could say it was FRAND, and question about how it had been argued below. If I may just take the court to 3 short paragraphs of the judgment. paragraph 9, where this was where the point had arisen about whether it was an interim declaration under 25.1b, 11b, but Lenovo is not asking for a declaration that be revisited at trial. It's rather declaring what wouldn't do in the current circumstances, a short-term license. Of course, it was always with an adjustment clause. He then came back to that at 37, where he recorded the submissions from Mr. Cavender KC, who characterised the judgment in Panasonic as a significant advance involving the English court creating an interim remedy for a short-term FRAND licence to hold the ring. So there's no doubt that was being put forward. And in relation to actually does he need to, or is he being asked to decide whether the Lenovo offer is FRAND? Well, the judge did refer to that at paragraph 83, where he sets out that there was evidence from Ms. Dagg as to why the offer may be supra-FRAND, but then he notes that in paragraph 51 of its skeleton argument served in advance of the hearing, Lenovo wrote back from the invitation that I decide that the October 2023 offer was supra-FRAND, saying it's not a point that the court needs to determine at this stage. So it was pretty clear from Lenovo's position, and that arose from Panasonic, in effect, as to how the approach should be done. My lords, I think the points on the respondent's notice, we have given you those in our supplemental skeleton, and I was going to rely on those, particularly looking at the time, but I do obviously rely on them and commend them. We have the licence. I can't read that. My lord, lady, if you'd like the licence now, or would you prefer me to send it later?
Got it now. Let's have it.
I didn't know we had it actually, so I wasn't being deliberately coy.
And I think Mr. Pickford would like one too.
Oh,
I've literally never seen it.
oh, okay.
If there aren't enough, that's fine from our point of view. We can sort it out
Yes, I
internally.
apologise. It's a bit of a. There are 3 here. Yes. And I've been told that, although it's a confidential licence, I am allowed to read this clause, which does not come to a lot of surprise considering what we've been submitting in open court. And it's what we rely on is paragraph is article or clause 12 on page 16 of this agreement. Where it explains that all disputes, differences, questions between the parties relating to the construction and interpretation of the agreement shall be finally settled by the courts, civil courts of London, United Kingdom.
Thank you.
Mr. Pickford.
My lord, lady, oh, I was about to say those are our submissions, but thank you.
I was simply going to address this point. Obviously, I can see as well as the court can see what clause 12 says. I think all that I was being asked to clarify before was what our pleading says on the matter, and our pleading did not. I'm just going to. Can you unlock the screen, please? Sorry. The position adopted in our pleading on this is, as I understand it, again, it's not something that I can claim familiarity with, is it's admitted that clause 12, accurately quoted in the reference is the laws of the United Kingdom, is to English law, without prejudice to the fact that the defendant does not contest the English court's jurisdiction over this claim, and without any admission as to whether England is the proper or exclusive forum for any such dispute, for the avoidance of doubts, it's denied that the effect of clause 12 is as alleged. I'll simply be asked to make that point, but I'm not going to be taking a point, and I wasn't seeking to take a point about clause 12 of this agreement.
And Mr. Lycodopoulos, I cut you off a bit. Was there anything you did want to add?
No, my lord and lady, I think those are my submissions.
Thank you very much. Well, We won't, of course, be giving judgment here and now. As is the normal practice, you will be supplied with the judgment in draft for you to correct our English and typing, but not to re-argue the points. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we'd expect to deal with the points in the order that we make. And I ought also, though I know you're very well aware of it, to remind you of the importance that's attached to the embargo. So if you think of anybody extra who ought to see the draft judgment, you obviously need to come back to us. But other than that, it remains to thank those who have had speaking roles and those who haven't very much for their very helpful submissions.